Welcome to the June webinar from the Carpenter Law Firm. We're broadcasting live from the Carpenter Law Firm studios. It's my office. It's a little joke that I tell at the beginning of each webinar that I do here at the Carpenter Law Firm. My name is Scott Carpenter, if you didn't know that. I'm happy to present these on a monthly basis, and today we confront the question, are owners more challenging than they used to be? And of course, this question, in order to ponder it properly, you have to be in the business of doing community association work for some period of time in order to compare and contrast how difficult owners have been. And I'm assuming today that those of us that are participating are in the business. We're directors or professional community managers, and that the difficult owners are not participating today. Of course, it's possible. I put these webinars on my website. So whatever we say today is, of course, going to be out there on the web. And I'm not going to calibrate my words for that possibility. I'm going to be raw and unedited in my comments today, as helpful as I can be for, as we sometimes call it, the industry. And so I'm going to ponder this question. Some of us have been around for a long time. And I say this as a matter of fact, not bragging, because there's not a lot of bragging in this. I started in 1994. We all have an origin story, how we came about to be in the community association realm. My origin story is not that interesting. It has to do with my mother-in-law, who was a professional community manager, who had a son-in-law who was looking for a job in a difficult economy in the early 90s. Some of you may remember the savings and loan debacle and a lot of real estate that was on the market. And it was a difficult time. I just wanted a job. I wanted to support my wife and baby at the time, my baby who is now an ICU nurse and thriving, but we all have our stories as to how this happened. So we confront the question today, are owners more challenging? And I'll tell you my thought at the beginning. Yes, they are, for many reasons, and I'll tell you a few of them as we go. So the first thing we'll say is that the Arizona legislature is still in session. They start in January every year. Some states are lucky that they meet every 2 years. I grew up in Texas. My state of first licensure to practice law was Texas, as we sometimes say it. But in Arizona, we have the privilege that the legislature meets every year to enact laws and regulations. And every year they pick on associations. I will have my legislative update prepared in this format 4 weeks from today, July 15th, 2025. I'm going to give you a quick example, and I did this a month ago. Senate Bill 1039 has already been signed by the governor. This is the extent of the regulation, and this is verbatim from the statute. If a board records a meeting that is open to the members, the board shall means must, keep a copy of the recording for at least 6 months and make the unedited recording available to any member means owner, on request in compliance with section 33-1258 subsection A. I've copied the condominium version. That's the 1200 series of Title 33, subsection A. This means an owner can request the records on 10 days notice, and you have to make the copy available. Well, here's my problem. There's always a criticism. The board records the meeting on purpose. Sometimes. And during the pandemic, we got good at recording meetings on Zoom or conducting meetings on Zoom. I have a number of clients where they conducted meetings on Zoom, but due to accidental settings in Zoom, the meetings were recorded to the cloud. What is the cloud? Well, it's just recorded by Zoom on computer servers and hard drives out there somewhere, owned by Zoom, accessible by the user using the username and password. But the board did not know it was recording the meeting. Maybe the community manager did, but the board recorded the meeting. The board has to keep a copy for 6 months and make the unedited recording available to the member on request. Some of my clients recorded the meeting that was conducted via Zoom on purpose. So the statute says if the board records the meeting, you have to keep a copy for 6 months. Well, here's my problem. I've been to many meetings where Bob, the secretary, pulls out his phone or a recording device and sets it on the table to help him keep accurate minutes. It's his device. It's owned by Bob. We could say Betty, the secretary. We could say Bob, the secretary. It doesn't matter. We're not going to assume the secretary is Betty, but Bob, the secretary. Bob pulls out a recording device. And as best I can tell, I'm the attorney. I'm a guest at the meeting. I show up. Bob or Betty pulls out a recording device, sets it on the table, hits record, looks over at me, and basically says, in words or nonverbal communication, do you mind if I record? And I say what I've always said my whole career, no problem. Now, deep down, does that bother me? No, it doesn't actually. I'm going to say the same thing one way or the other, but some people, it might bother them or it might not. So Bob records the meeting on his device. It's owned by Bob. The board did not vote, in my presence at least, as far as I can tell, to record the meeting. The device is owned by Bob. The premise of the third bullet point on the screen is the board records the meeting. Bob recorded it. Betty recorded it. And second clause after the comma, the board shall keep a copy of the recording. Well, Bob has possession of the recording. Betty has possession of the recording. So now we're in a situation where somebody in the room, an owner, because that's our topic today, the owner wants a copy. The owner goes to the manager and says, I want a copy of the recording. And the manager says, I don't have it. The management company doesn't have it. And the owner says, well, I saw the recording device on the table. And the manager says, well, that was a personal recording device of that director, Bob, Betty, whatever. We don't have it here at Acme Management. I'm making that up, whatever the management company's name is. Can the association get out from underneath that obligation to provide the recording by saying the board doesn't have a copy? And when we say the board, we mean the board, the association, the management company, probably all wrapped together. But you can see how this legislation, the complete legislation, the complete regulation, the complete statute is the third bullet point. You can see how it's going to be frustrating, at least in that scenario where a director on his or her personal recording device, which doesn't have to be a cassette recorder, could be a phone, owned by the owner or the director, becomes complicated because the statute assumes that the board intentionally records the meeting and the board, association, management company, whatever, keep it all the same. I think that's the intent, retains the recording, the data file ownership, and then the association can produce it. And this is why the legislature and the lobbying that goes on becomes so frustrating. And I'll tell you why exactly. I've been a volunteer lobbyist at the legislature my whole career. 31 years, 1994. I mean, we've already discussed it. It's because the legislature enacts laws based on a homeowner, a citizen, telling their story. And we know the story behind this law. It will be law after the session adjourns, but it's still in session. Because the homeowner testified before a legislative committee, and we have the video. It's on the legislature's website. And he testified about his story, his legislation by anecdote, his story of what happened. He went to the legislature and he told his story. Hey, members of the committee, hey, legislators, there was a recording and I wanted a copy. And the association wouldn't give it to me. And the association had its lawyer get involved and tell me I couldn't have it. And so I went to my legislator and I told my story. And my legislator introduced Senate Bill 1039. And I'm here before this committee to urge you to recommend that it pass the Senate. And then Senate Bill 1039 passed the Senate, was moved over to the House. It passed the House. And then Governor Hobbs signed it. So now this is what we have. All based on the premise that every meeting that's recorded is recorded intentionally and with volition by the board. And that's the only way it's recorded. When those of you who were participating in this webinar know that the scenario that I outlined is actually quite common. That Bob or Betty, the secretary, often records the meeting on their personally owned device. And then that data file, back in the old days, we would call it a cassette tape. That magnetic strip of tape is now back in their home, back in their unit. And the board does not have access to it. It's not at the management company. It's not in the association's office. It cannot be produced easily by the association based on a demand under the Books and Records statute. So this is what we will discuss on July 15th. There's more to discuss on July 15th. There are already 6 bills that have been signed by Governor Hobbs. There's a 7th bill that's still pending that may pass. And we may say when it's all over that this is the worst one. I don't know. We'll see. There was another bill, enough previews. Let's talk about whether homeowners are more difficult than they used to be. But here's one of the reasons why. Here, let me give you a legislative example of a difficult owner. There was a bill that was introduced by Representative Neil Carter. And this bill would have, if passed, said that there would be no attorney's fees award to the association when the association prevails in enforcing the CC&Rs, whether that's in an assessment collection case or a covenant enforcement case. Now, as you know, lawyers go to court for 2 broad reasons: to collect assessments and to enforce the covenants. When I say enforce the covenants, I mean someone painted their house pink or purple, put a gazebo in their front yard, has RVs parked in the front yard, or a boat parked in the front yard, something like that. And I talked to Representative Neil Carter, and I outlined the following scenario. Let's assume there's a high-rise condominium and its annual insurance premium is due. And I told him, let's assume the premium is up 40% over the previous year. And those of you participating in this webinar know that that has happened. the premium is paid from cash on hand. And let's assume the cash on hand is in the reserve account. Now, we all know the reserve account is not there to be a savings account. It's there for deteriorating assets that need to be maintained over time. The reserve account is not to pay operational expenses like the insurance premium, but sometimes it has to be done. So let's assume that's what happened. And I said this to Neil Carter, when the premium is up 40%, every once in a while, cash management requires that the reserve fund be used on an emergency basis. Let's assume that's what happened in this hypothetical I'm creating, which I did for Representative Neil Carter. In a world where no attorney's fees can be awarded when the association prevails using a lawyer to enforce the CC&Rs, whether it's assessment collections or covenant enforcement. So that's the lay of the land. The landscape is you can't get your attorney's fees awarded to the association when it wins using a lawyer to collect assessments or enforce the covenants. Premiums up 40%, reserves are used. An owner refuses to pay assessments going forward in protest of the fact that the insurance went up. Now, if you think this is impossible, then you haven't been around community association work very long. People do this kind of thing. Now, as we know, the rest of the owners have already covered the premium payment from cash on hand. Everyone participated in contributing to the cash on hand. The premium's been paid. The rest of the owners have also contributed to the attorney's fees to sue the owner who refuses to pay in protest. Now, what Representative Neil Carter has done in proposing House Bill 2865 is required that the difficult owner's behavior in not paying would be subsidized twice by the complying owners. First, by the insurance premium being paid by everyone who is complying. And second, by everyone who's complying and paying all the legal fees to bring the non-paying owner into compliance. Now, what I suggested to Representative Carter is that the way to cause a death spiral of all community associations in Arizona is to essentially create a situation where the first owner figures out, I don't have to pay assessments because the association cannot pursue me and gain an award of attorney's fees. Everyone else will pay the attorney's fees, but if they don't pay the attorney's fees, then the association can't chase them either. Eventually, everyone will figure out they don't have to pay, and there will be no one to pay the assessments or the attorney's fees to chase anybody else. Was that his goal? We don't know for sure. But Representative Carter believes that a majority of people in community associations are dissatisfied with their association, and that something has to be done, killing them by making it impossible for the association to collect assessments and bring about covenant enforcement is probably the fastest way to kill them and to make sure that they don't exist anymore. Is that the solution? Hard to say. So this would create a lot of difficult owners because eventually, not eventually, but pretty quickly they would figure it out that If you don't pay, the association may hire an attorney and get a judgment for the principal amount owed, but the attorney's fees on top would never be awarded. So this is an example of a difficult owner. On July 15th, we'll cover this briefly, but because it didn't pass, we won't spend a lot of time on it, but it may be back next year. That's Representative Carter has promised that it will come back. Okay, are they becoming more difficult? In my view, based on my experience, owners have always had opportunities to be challenging, resisting opportunities to comply, resisting opportunities to pay. One thing I've seen that's new is that owners are using artificial intelligence. They're using AI in ways that um, are new. In fact, I just saw something yesterday that I hadn't seen, which I'll tell you about in a second. Owners are using AI to claim legal expertise to board members. They're using AI to claim legal expertise to community managers. And I've now seen AI on dedicated community critique websites. Let's assume that there's a community called Del Boca Vista Owners Association, and someone goes out and purchases the domain name dbvoa.com. You can see that that's the acronym Del Boca Vista Owners Association, or dbvoasucks.com, something like that. But one thing I noticed in this scenario was that an owner took video of a board meeting and then chopped it up and then used an AI person to critique the board meeting, edited board meeting, chopped up the video, and then, as best I can tell, typed up a critique of the meeting, and then created a persona talking head. You may remember from the 1980s, first version of this was Max Headroom, that kind of talking animated person, but better than that, sort of a person that looked real and talked to critique what was going on in the video. And there's no fooling me. I could tell this was not a real person conducting a real critique. Was not a lawyer, was not a real person. There was no claim that this was a real person. It was just words spoken by a human looking animation, but no fooling anybody. But to me, that's difficult because there's a website that's critiquing board behavior. And we're seeing more of this. It's difficult when a board is attempting to operate in an environment where owners are using technology, websites, and what I call dedicated community critique websites. That's difficult. And we've litigated that here at the Carpenter Law Firm a number of times since I left my former firm, and had good success litigating whether a homeowner can impersonate the association, especially with these abbreviated versions of the initials of a community. It's difficult because it's expensive, but other than that, the legal issues are not all that complicated. So it is difficult to deal with owners who believe that they have an absolute right to free speech. Free speech is a limitation on the government quieting citizens who have a right to speak their mind. But in the association context, an owner does not have an absolute right under the First Amendment to say whatever they want to in a nonprofit corporation context. So it is difficult to deal with, but other than the expense, which is not minimal, hourly rates have changed a lot over time, but this is new. And the AI angle is not difficult legally because owners do not have a right to be difficult in this regard, but it is new. They are becoming more difficult because they feel empowered. And in fact, on a matter I've dealt with recently, every time that I corresponded with a particular owner, every response I received, I could tell had been written by AI. You could call it Chat GPT. Every time that I received an email, I could tell that it was written with the assistance of artificial intelligence. And you might say, well, gee, Scott, how can you tell? Well, just everything about it uh, just felt not genuine. I could tell that it was written with the assistance of computer intelligence. You might say, well, how arrogant of you. How can you tell? Well, just, the sentence structure is just artificially created. Well, here's a couple of ideas. One of the things that owners love to do, and it really goes back to the beginning of my career, I've encountered owners, and in this sense, it's not more difficult. I've encountered owners that love to engage in the back and forth with me, with lawyers in general. In my firm, um, we encounter owners who seem to love the engagement, the battle of going back and forth with the lawyer. And you think, well, shouldn't they hire a lawyer? Well, actually, they should. But there are some people, and I call it they wish they had gone to law school owner. They think, well, I could have gone to law school. I could have been a lawyer. My uncle, who is a lawyer, told me I should have gone to law school. My parents told me when I argued with them in high school that I should have been a lawyer, and I never did. And a little part of me regrets it. I was on the debate team in high school, and I thought about going out for the debate team in college, but I didn't. I thought about taking the LSAT in college, but I got pulled in a different direction, and I've made good money. But now that I've got this dispute with my HOA, I think I'm going to decline to hire a lawyer, and I'm just going to handle this myself. There are a lot of people in that category. And one of the things that good lawyers do is we have to be the ones to see that early on and say back to our client, the board, the professional manager, the legal fees are going to be higher unless we stop the back and forth. This owner is writing long letters and enjoying the back and forth. We have to decline the endless back and forth letter writing campaigns because it's not advancing the interest of the client. And here's why it's so important for the lawyer to see that first. The goal of demand letters from lawyers is compliance. If the letter is not going to bring about compliance and convince the owner to change his or her behavior, then we have to bail on the strategy. And the lawyer has to be the one to say, this isn't going to work. If the lawyer can't be the one to say, my letter is not going to work, then the lawyer's a bad fit for the problem. Because the alternative is that the lawyer is going to continue to bill, the lawyer is going to continue to make a lot of money with the constant back and forth. The letter has to be the lawyer has to be the grown up to say, I've written 5 letters back and forth. We're not advancing the ball here. The goal is compliance. We either need to bail on the strategy of writing letters or we have to take the next step. What is the next step? Unfortunately, often the next step is a lawsuit, which is more expensive. But the endless back and forth of letters to owners or back and forth of letters to owners' attorneys is only effective if we're on the cusp of compliance. But the goal of the letter has to be to convince the owner to change his or her mindset about compliance, not to enrich the lawyer with one more letter, one more $500 letter, and maybe we'll get there. I love this quote: never wrestle with a pig. You both get dirty and the pig likes it. I'm not saying owners are pigs, but that's the problem with the endless back and forth of letter writing campaigns. If we're not close to compliance, whatever that might be, then one more letter is not going to make a difference. This happened to me yesterday. I wrote a demand letter to an owner, and the letter said, I'm not going to write a series of letters. This is your one letter. I emailed the PDF to the owner. She emailed me back. I responded to her email. She emailed me again, and I said to the client, I don't want to respond again because I think she's enjoying it. This is exactly what I didn't want. And I didn't time that for this seminar today. It just happened to be yesterday where I realized she's enjoying this. And this is exactly the point I'm making today. I said, this is one letter and then there's a lawsuit. We're not going to go back and forth. And she got around that by responding back to my letter via email. And then by the end of the day, I'm 2 emails in. And she's inundating me with AI. And then I'm in the vortex. Like, no, bail, timeout, client, this is exactly what we didn't want. We said one letter and then a lawsuit. No way. Okay. This is what we don't want. We don't want to overall drive up the legal expense. I send a flat fee letter, 2 emails in, and all of a sudden we're in the vortex. Some lawyers enjoy it. I mean, this is what we do, and all of a sudden, I'm accusing the owner of enjoying it, but the lawyers like it too. And the lawyers should not put the client in the position of having to recognize the problem. I'm recognizing the problem from the owner's perspective. The owner likes it. The lawyer should not put the client in the perspective of saying, hey, I think my lawyer likes this. We're four letters in, and now I have to call timeout on my own lawyer. Hey, Mr. Lawyer, Ms. Lawyer, are you enjoying this back and forth stuff? I mean, you write good letters, but we're not anywhere closer to compliance. All we have is strong letters, and we're not anywhere closer. If you're the client, that's a fair assessment. You've got legal bills at the end of every month. We've got four letters. We're 120 days into the dispute and no closer to compliance. That is a fair criticism. And then at the end of all of that, you get to ask the question, now what? The back and forth is over, or it's fizzled out. Where are we? Are we going to file a lawsuit? And by the way, that back and forth of letters is not litigation. The word litigation means one thing: a lawsuit has been filed. And if you thought the back and forth of letter writing is litigation, it's okay. There's nothing wrong with that erroneous thought. But I encounter that every once in a while in my legal practice where board members and every once in a while a community manager will think that the dispute posture of lawyers writing letters back and forth is a definition of litigation. And I just want to take a moment here to correct that. Litigation means lawsuit. So under the books and records statute and the open meeting statute, when we talk about the board can meet in executive session to discuss pending or contemplated litigation, the word litigation in the open meeting statute means pending lawsuit or contemplated lawsuit. It doesn't mean the back and forth of letters from an owner to the board, the association, or between lawyers. So when the back and forth ends, either because it fizzles out or somebody puts a stop to it, the next step usually is a lawsuit, whether filed by the association or by an owner. So let's talk about the vortex of litigation, the vortex of being in a lawsuit. Can we avoid it? Well, as I've mentioned before, we have courtesy letters, we have monetary penalties, and we have injunction lawsuits. We have the courtesy letter and the idea of a courtesy letter. You know, I live in an HOA and I'm doing some work on my house. Actually, I'm not doing it myself, but there was some demo work that was being done, and there was a waste management, what do you call it? Kind of a bag, you know, with two handles that was holding some demo stuff in the front yard. And we got a courtesy letter that said, hey, it's not bulk trash pickup week. This is in the town of Gilbert. And, you know, my wife said to the HOA, hey, you know, we're doing some reno. And the manager correctly said, well, I'll take it to the board. And we didn't hear anything for a while. And by the time we heard back, it was all gone. Waste management had come and picked it all up. And that was all off of a courtesy letter, basically a courtesy letter, which we explained. And now it's been resolved. So we're happy about that. No monetary penalty was contemplated or imposed, and thankfully no injunction lawsuit. So every once in a while, even HOA lawyers get on the wrong side of their HOA for having trash in their front yard, which I do not like. I don't want to get in trouble. And, you know, so every once in a while, you know, even community managers, HOA lawyers end up in this list. So, you know, here's the way we look at it when we evaluate these options. Courtesy letters will work for some owners, certainly work for me. My wife doesn't want to get in trouble. I don't either. Fines must be reasonable according to the statutes. I like big fines. I've always thought that we need to have much bigger numbers in the fine department. This is what I call the Scott Carpenter rule. I don't know if anybody else calls it that. I don't need anybody else to call it that. The numbers must be a deterrent. You know, owners may be more difficult. If they are, we need big numbers. If somebody has an RV that they're storing in their driveway, and the RV storage down the street is $500 a month, we need the fine to be $2,000. It's It's got to be a big number to be a deterrent. It's got to be economically advantageous to move it down the street. And frankly, we don't even know if $2,000 is going to be a deterrent for the average person. We don't know if that's even enough. If the storage down the street is $500, the fine cannot be $550. People who own RVs, I think, would pay $50 a month to have it right there at the house. We can't play games with economic rationality. If the offsite storage is $500, an RV person, and we have to understand the mentality. An RV person would pay $50 a month to have it right there. We can't play games of slivers with an RV person's economics. That's why it can't be just a little bit more than the offsite storage. It's got to be big. And that's why I say 2,000 or 2,500. And I don't know that 1,000's enough. It's got to be reasonable, but it's got to create an economic deterrent. And that may not even be a good example, but it's got to be big. The bigger, the better. And here's the worst case scenario. Let's say you do it 2,000. They don't pay it. We sue them for the 2,000, and we end up in court. And the owner hires an attorney, and the attorney goes into court, pounds the table, screams in advocacy that it's unreasonable under the statute. What's a judge going to do? Lower it. Lower it to what? To a reasonable number. If 2,000 is unreasonable, the judge might lower it to 1,250. I don't know. I'm making this up right now. I'm just trying to illustrate my point. If 500 is the offsite storage number and we impose 2,000 and the owner goes to court and the judge says that's unreasonable, a reasonable amount might be 800 or 1,250. There you go. But let's don't make the owner's argument for him or her. Let's litigate it. I mean, sure, it's easy for me to say let's litigate it. I'm the attorney. I get paid hourly in this hypothetical lawsuit, but we don't need to concede the point before we even end up trying to deter the behavior with a bigger number. And then we have Superior Court injunction lawsuits. This one's best for the lawyers. Hourly billing, it's an option of last resort. But big fines tend to create the deterrent effect that we're looking for. Most people don't want to fight the battle. They don't want to pay the lawyer to go fight a big fine. We end up settling, but the behavior has been deterred. So in reality, an owner who wants a confrontation will be successful in creating the confrontation. Man, I've learned that over the years. If somebody wants to come to a board meeting and create a scene, they will succeed. This was in the pre-Zoom days. Even on Zoom, if somebody wants to create a big confrontation and that's their goal, they will most likely succeed. The confrontation, however, in my experience, does not achieve a successful result on the underlying issue, whether they want forgiveness of a fine, a reduction in assessments, allowance of an RV parked in a side yard, whatever the issue is. The confrontation in and of itself does not achieve success on their underlying issue. Whatever that substantive issue is, waste management, trash in the front yard. If I want to create a scene about that, I could march over to the management company and get into the lobby and scream and yell about it. But that does not resolve the issue. I've just created a new problem. I mean, that's, I don't mean to be funny about it, but I will lose on the waste management issue. As we all know, human nature. I can create a confrontation about it. It's no different than going on YouTube and watching someone get pulled over for suspicion of DUI and then resisting arrest. The confrontation over resisting arrest never helps. They're still getting the DUI. The craziness about resisting arrest is a new charge, but the DUI is still there. Our job as professionals in this industry is to differentiate between drama, which we have to disregard, and the merits of a problem. This is why this is what happens with well-trained police officers. They disregard the drama and address the merits of the issue, which is the field sobriety test, um, the the DUI part. They differentiate between that and the resisting arrest, I guess, is kind of the point I'm trying to make. Maybe it's not a good point, but I think there is a good comparison there that a well-trained police officer can sift through the noise of a crazy situation and get to the heart of the criminal conduct. And we have to do the same thing in our own kind of way in what we do, which is the bad homeowner behavior and get to the underlying issue, which might be a parking issue, an architectural issue, a failure to pay assessments issue, and sift through all the noise. All right, we do our questions in this webinar format through the chat feature. I'm happy to try to address some of the issues that we brought up today. If not, that's cool too. I will look forward to seeing you all on July 15th. We'll have plenty to go over with the 2025 legislative session. Thanks, everyone.